Hello, everyone. I'm Sue Taylor, and you're listening to a Sitting with Sue podcast. Today, I'm delighted to have sitting with me Thom Lumley, who is a partner at RPC, and he's an insurance lawyer specialising in UK casualty claims. But Thom, can you give a little bit of background information on your career and your current role, and then we'll get into the questions.
Well, thank you for having me first and foremost, Sue. Really delighted to be here. I've been fortunate enough now in my career to work at three large law firms, both national and international, all with a drive for insurance work and with particular focus on my area, so general liability and casualty claims. My current role is as a partner at RPC, and I will support a host of different clients, spanning those in the London market to composites or corporates and local authorities, with my focus on casualty work. And this can include coverage, liability, general advisory work. It's a market-leading team with some excellent lawyers. And what's really cool is there's lots of collaboration in the team, lots of idea sharing. We discuss legal development, how we can try and set ourselves apart and work together to deliver true value to our clients, and also inject some human personality into our work too.
That's really interesting, particularly the bit about the fact that you're using multi-skills in the process. Therefore, I've actually got to ask you a personal question. How similar are you to your parents or your siblings?
Typical lawyer answer would be similar but different. My dad worked in social care, so there's a fundamental difference there. But he was, and still is, an excellent listener. And it's very important as a lawyer or for anyone in professional services to be a listener. And Dad, he'd always remind us as kids to, when speaking with others, to be on receive and not just transmit. Listen, don't just focus on what you're saying next. My mum's a real people person, someone who can talk to anyone. She's always out doing things, sorting out an issue for someone. She's got a lot of get up and go and the life and soul type, I suppose. So I think I've been lucky enough to gain some of the traits from each of them and apply them to my work and personal life. Although my dad also wasn't quite straight with us on a few things. So as kids, he told us once that Darth Vader ended up in that suit because he didn't wear a seatbelt. So I'm now beginning to question a lot more of what I was taught as a youngster.
I'm sorry, Thom, but I'm now forevermore going to envisage you in a Darth Vader suit. I'm never going to be able to look you in the eyes again. Let's turn to the serious stuff and dive into the world of personal injury claims and damages. So let's actually start with the basics of what makes up a claim for compensation in a personal injury claim.
Sure. Well, broadly, it's broken down into general damages and special damages. So general damages are your non-pecuniary losses, so your non-financial. These predominantly relate to pain, suffering, and loss of immunity. So this is the physical element of your compensation. But then they also cover, and we're seeing more and more with claimant lawyers, including these within the general damages side of schedules, things such as Smith and Manchester, loss of congenial employment, and other such losses. Your special damages, or your pecuniary losses, they're things that often make up the largest part of the claim. These are your past or future loss of earnings, travel incurred, whether care or assistance, attendance were provided. These are losses that are secondary to the injury and are often the larger part of the claim. Where we have more serious injury, this is when we get into elements of future financial losses. So your future loss of earnings, future care, nursing needs, aids, equipment, prosthetics. And prosthetics is particularly interesting as it's moving at a rate of knots with technology. And of course, people are living longer and much more active lives. Things are much more available to us now. So these have life cycles and will have replacements at set periods. So you might be calculating equipment costs with replacement every, say, 6 to 10 years over a period of 40 years. It's very interesting, and on the larger claims, this is where probably the most amount of time is spent, and it involves all manner of experts to support with the assessment: medical, non-medical, accountancy, employment, accommodation, all sorts. It's very interesting.
Thanks, Thom. You've just covered a huge amount of ground. So Where are the starting points and also the tools for actually assessing these heads of cover? I mean, where do you actually begin?
Well, for practitioners, lawyers, and handlers, we're fortunate that we have a host of tools at our disposal. So there's a starting point, whether it's an attritional, a lower value loss, or even a catastrophic loss. We have the JCGs, or the Judicial College Guidelines. They're now in their 17th edition. These are the starting point on Injury Practitioner's Bible. They help with guideline brackets for pain, suffering, and loss of immunity, the PSLA I referred to earlier. There's constant updates, inflation's a major issue, and they just give you a useful starting point for brackets. They'll cover off most types of injury, brain injuries, amputations, orthopedic injuries to different parts of the body, scarring, psychological injuries. And it's helpful to have that from the offset. Sometimes the brackets can be quite broad, but as I say, it's a helpful starting point. With insurance and stability or predictability and consistency ever important, the case law is becoming ever more prevalent. I won't get into fixed costs, but that's also key. With the level of damages relating to fixed costs, the fight on accuracy of damages is incredibly important. So other tools will include Kemp and Kemp, online case law tools, all valuable resources to find the most comparable cases and naturally damages awards. So you can add weight to your assessment and, well, set a sensible reserve at first touch. We also have a host of actuarial tools, indices. So we have the Ogden tables, we have facts and figures, or ASH, the annual survey of hours and earnings. These will support practitioners with larger losses over periods of time, especially where there's fixed and changing periods, and they can help where there's a host of contingencies. But as with most of the job, much comes down to evidence gathering and shaping that.
So what happens if there's more than one injury? So, for example, someone falls and they break their wrist, then they chip a bone in their elbow and they twist their knee. So none of those are actually catastrophic, but all of them have consequences. So how do you unravel all of that?
Well, the starting point is PSLA is incredibly subjective. You really have to think that one injury to one person is very different, a similar injury to another person. And when you've got multiple injuries or polytrauma, it can become a little more complicated, and you have issues of aggregation. So, adding up various different heads of injuries. But it's important to remember starting principles of tort. So it's to put the injured person in the same position as they would have been had they not suffered the tort. Where you've got a number of injuries, simple aggregate isn't necessarily right. Sometimes it can represent overcompensation. So there's a fair amount of case law on this. You've got Sadler and Philly, Pyack, and more recently, there have been some developments around mixed injury awards with Hassam and Rabbit as well. The correct approach to consider whether the total award for PSLA should be greater than the sum of all parts in order to properly reflect the combined effect of the injury. So sometimes if you add up all of the different awards, it might not accurately reflect the level of harm, suffering, loss of immunity that they've suffered. Whereas equally, sometimes it could be overcompensation. You mentioned earlier, I think, 3 different injuries. One of those in itself could provide a similar level of lost amenity than all 3. And that's where you then have to look at the pain element and look at it quite carefully. So it's an interesting area of law. And again, notwithstanding the value of the claim, it's incredibly important that handlers look at this through a claimant lens almost to come up with the most accurate assessment and indeed to form your arguments.
Very interesting. You mentioned loss of congenial employment earlier. Could you explain a bit more about what that involves?
Yes, of course. It's an interesting head of claim. It doesn't appear, historically, it doesn't come up as much as I think the textbooks would suggest. And technically, it falls part of the General Damages Award. So it's where a claimant is precluded from doing a job they enjoy. And the preclusion needs to be by reason of their injuries. An early case was back in the 60s. It's Morris and Johnson. And in that claim, the claimant was a skilled metal worker who was injured and unable to continue in his role. The judge stated that the claimant had to replace the craft that he enjoyed with, quote, humdrum work. It's quite a helpful starting point. And traditionally, where you may see it the most, loss of congenial will be applied to a lot of the uniform professions, doctors, nurses, firefighters, and the military. But even talking about Morris, that was a metal worker. Case law would confirm that the award is not necessarily limited to the type of employment. And again, with the PSLA element, rather a more subjective analysis needs to be undertaken regarding job satisfaction, how the role made the claimant feel, and it's a head of claim that applies to all manner of job. So there's construction, there's case law on model makers, kickboxers, florists, and I'm pretty sure even a manhole constructor succeeded in a loss of congenial employment award. Assessment itself is tricky, and again, it's very fact sensitive. So damages are often a few thousand to say £5,000 to £10,000. And there was a more recent case in the past, I think 4 or 5 years, Appleton and Medhat, and that involved a professional footballer where I recall the sum was in the region of £25,000, which was awarded for the loss of congenial employment claim.
So he obviously liked his football. But costs naturally are a large part of claims. Could you talk a bit more about how these feature in personal injury claims?
Yeah, of course. I've been in this sector now for coming on for 2 decades, and there's been huge amounts of change to costs, introduction of fixed costs being one of the most important. But we would have years of time where even for the attritional losses, your 2, 5, £10,000 claims, you'd be presented with bills of costs in the tens of thousands of pounds. There'd be success fee elements as well. So costs in a claim, they can include claimant costs, defence costs, as well as adjuster or expert fees, disbursements. For claimant costs, principally, we have guideline rates, which should be heeded. These will relate to an hourly rate, and they tally to the location of the claimant lawyer, their post-qualification experience. And for the lower value claims, specifically those up to 25,000 on the fast track, we've had fixed costs now in casualty for, it's got to be in excess of 10 years, 2013, 14, summer 14, I think it might have been. So we're all quite well versed in fixed costs. And of course, some of your listeners will probably be aware of the cost reforms that kicked in last October. So within that, we've had the introduction of a new intermediate track, which covers off, I think the phrasing is simpler claims, but I know people will certainly disagree on that, with a value of up to 100,000.
Yeah, could you just expand a bit on that as to what you're seeing as a result of the introduction of that new band?
It's still early days, so a lot of these will be pre-lit at the moment, given the October position last year. We are seeing, and what we're hearing through the grapevine, is a lot more, and again, it's people pushing the system. You know, if you're told that you're only going to get a certain amount of costs within a certain bracket, then naturally there's the incentive is sometimes say, well, hang on, there's got to be more to be had here. So what we'll see sometimes is more medical evidence, more heads of claim. So again, some of the less regular heads of claim that we talked about earlier are probably going to become more prevalent. Opportunity to increase the damages in claims would naturally have a corollary effect on costs. So handlers need to be very well versed in these changes, both in terms of reserving and of course, costs arguments. There is actually, I suppose, probably a bit more of an opportunity for sometimes a more accurate reserve on costs. Sometimes there can be more variance or swing. So say, for example, where you've had claims that started as a letter of claim, but then maybe get allocated to the fast track, or conversely, claims that started in the portal where fixed costs should attract, but then perhaps exceed £100,000 as the evidence has gone on. You can deploy some quite interesting strategies there where you may be incentivized to settle sooner due to the cost savings, because of course costs can make up a very large percentage of the claims. But in any event, over the past 10, 11 years, and certainly into the future, cost is becoming an ever more focal battleground. So good claims handlers and lawyers stay up to date on these, seek out additional training where necessary, get your reserves right at the start, set out your thought process behind it.
So what are some of the big changes and developments that you're actually seeing in the handling of injury claims? Because obviously things have changed over recent years, but what's the current trend?
I think it's something that's affected society as a whole. I mean, social media. certainly not new. I think what people will not post to the world, it's remarkable. You'll have lawyers and handlers corresponding on quite sensitive claims and issues, and sometimes people will be sharing a very different story on their social media page. So it can yield a lot of fruit to casualty lawyers and help us develop arguments around causation and the assessment of damage. We've uncovered individuals undertaking the chopping of wood at home, wall climbing, hiking. You'll also see posts on social media, perhaps from friends or family, where there'll be reference made to inebriation at the time of the accident, or even them being in a totally different location altogether.
Yes, I know some of these stories, you see them on Facebook these days, but I've done an awful lot on the surveillance side as well. I used to have one client that once a quarter we used to go and watch all the surveillance video footage. We had videos of a guy climbing a ladder who said he couldn't walk, another lifting a full set of clubs into the back of his car who said he couldn't raise his arm at all.
No, definitely. And surveillance is a really useful tool. And sometimes, of course, it can show the level of suffering that someone really is going through. And it gives insurers an early insight into that, but potentially earlier on than maybe their lawyers realize. So it can give a level of surety there. It can be expensive. And of course, you have the proverbial no-shows or limited footage, but it's something that I'd certainly endorse. But there's other technological developments as well. So we have the wearable tech, things that's omnipresent, well, pretty darn reliable. Fitbits, Apple Watches, things like that. And of course, your mobile phone, you can check the health on an iPhone. Other phones are available, but you can check within that, and it will say how many steps you've done, different types of heart rate, and where you've got someone perhaps portraying very different symptoms or restrictions, you can pick up from either their social media page, someone perhaps posting a strata or something, what they've been up to, where they've been hiking or cycling or things like that. Or alternatively, if they're a bit more savvy, and have not posted that to their friends or the world, you can potentially seek disclosure of these records, or indeed their bank statements, which might have monthly subscription fees, and it enables us to really press for the disclosure. And this data, as I said earlier, can show the genuine, or rather the inaccurate pre and post incident activity and changes. So it's very useful, some of the wearable tech.
Yes, I was actually watching a film the other night. It was a detective film, and it called for the sleep pattern records, and it showed that the person wasn't asleep. So I actually thought that they were the one who'd done it, but I got it wrong.
As long as we're not getting into some form of minority report of predicting accidents or anything like that.
But they were analysing all the sleep data on this particular film. A lot of this is actually weeding out the genuine versus the over-egged, if you like, isn't it? So it actually enables those to the genuine side to be dealt with quicker, I assume.
Yeah, and again, technology is it's everywhere. It's a wonderful thing, and has been for most of my career. It's been deployed where we can, but with it, the human element really comes out. So I joke that it's like the detective generation now, where handlers who've been doing this for 30 years or 3 months, we're aware of what we can do now on claims. The inquisitive nature naturally of adjusters and handlers is really realized. I'll regularly have adjusters or claims handlers having done some quite awesome inquiries prior to our involvement, all over social media, that have utilized Google Earth to the ends. They've naturally undertaken site visits, but that have undertaken checks on local web pages, or perhaps other employers or gyms, and completed financial health checks. And this really is excellent, as with a 3-year period of limitation, capturing as much information as you can early is useful for different data points. So yeah, no, it's really cool now that we've got the access to that.
That's brilliant. Thom, you've been absolutely amazing, but we're beginning to run out of time. So very briefly, what is an important industry lesson that you've learned? You've obviously learned a lot over the years.
Insurance and insurance law as an extension is a very small market, and it's also a very people-focused market. So we've talked about technology and the benefits of it, but I think it's ensuring that you always put people front and center to what you do. If you look after people, if you're straightforward and seek to understand their actual needs, you can often come up with some pretty cool and wow factor solutions, and hopefully they'll remember you for that. I see it certainly a lot on web pages and pitch documents, and it's achieving trusted advisor status. It's not a new phrase. It's an endearing and an aspiring accolade. But then there's more trusted partner status. So where you're really working in tandem with people, whether it's your clients, their stakeholders, or others. And I think trusted partner that's game changing.
The final question: what is the number one point you hope that listeners have learned from our conversation today?
I think it's just hoping that practitioners, lawyers, approach quantum in a claim and they've developed a better understanding of how to go about it. It's a fantastic area to work in. It's really diverse. As with all the changes that we're seeing, being familiar with all of the different heads of claim and evidential gathering and strategies and whatnot, I think hopefully if people can take that away, that's something. But the general liability and casualty insurance is an awesome area to work in. I won't go as far as saying anything cliched as no 2 days are the same, because they are, thankfully. But there's real opportunity for challenging the grey matter, personal development, your own career growth, because it's ever changing.
Well, that is brilliant. So that really does draw today's podcast to a close. And a huge thank you, Thom, for being so interesting and for joining me. For detailed information about any other podcasts, please go to my website at www.suetaylor.co.uk.